Current Trends Case Brief. R.V. Makara, 2017, SCC 59, 2017 to SCR 608. Facts Part 1. Makara sent text messages to an accomplice, W, regarding illegal transactions in firearms. The police had acquired warrants to search both Makara and W's home. From this, they seized Makara's BlackBerry phone along with W's iPhone. The police found incriminating text messages and charged Makara and sought out to use the text messages as evidence against him. Makara at trial argued that the messages found should not be allowed as evidence against him because they had been obtained in violation of his Section 8 charter right, which was against unreasonable search or seizure. The application judge then decided the warrant for Makara's home was invalid, meaning the text messages taken from his personal BlackBerry could not be used as evidence against him. However, the messages obtained from W's iPhone would be allowed. M was convicted of multiple firearm offenses when the judges admitted the text messages. Majority of the Court of Appeal agreed that what messages were found on W's iPhone did not ensure privacy to Makara, leading to why Makara could not argue against their admissibility. Facts Part 2. An individual does not lose control over information for the purposes of Section 8 of the Charter simply because another individual possesses it or can access it. So, this means that even if an individual does not have exclusive control over his or her personal information, only in shared control he or she are still reasonably allowed to accept that the information shared to remain safe from state scrutiny. Messages shared. Makara did have reasonable expectation to believe their privacy in the text messages shared with W and recovered from W's iPhone. Issues. Did the appellant Makara have the right to argue that his Section 8 charter rights were violated in an unreasonable search or seizure of the privacy of his text messages shared with W? Counsel for the appellant argued that his rights were violated under Section 8 of the Charter because he thought it was a private electronic conversation, where the respondent argued that what messages found on W's phone does not ensure the privacy of Makara. Decision. Makara was found not guilty because the application judge found that the searches of the text message conversations stored on the phones of M and W's both infringed Section 8 of the Charter, meaning that convictions were set aside and acquittals were entered. Rationale Part 1. The text messages that were found do offer a highly reliable and probative evidence in the prosecution of a serious offense, and Makara could be convicted because of the exclusion would result in the absence of evidence. Although, when the police were conducting and assessing and searching the electronic conversation between both Makara and W through W's phone, they did this without a warrant, and that was 2 hours after the arrest, and was sufficiently serious to favor the exclusion of the evidence. This breached the Section 8 of the Charter, not only for the reason of the extent of the search, but also because of the timing of the search. If the admitted evidence that was obtained from W's iPhone, Makara would have been acquitted due to the circumstances. However, he was convicted instead. To allow that conviction to stand would be a miscarriage of justice, and that means that the curative provisional in Section 686(1) III of the Criminal Code does not apply. Control doesn't need to be exclusive, and with the lack of exclusive control, this may lead to the diminishing of strength of a reasonable expectation of one's privacy. However, it doesn't eliminate it. Although, in the total absence of control in reasonable privacy, it is unprecedented and unethical to the notion of personal privacy, meaning if total absence of control indicates that a certain level of expectation of privacy is unreasonable, which means the individual doesn't have standing to challenge the search. Rationale Part 2. However, in this case, it revolves around the search of messages in a text message conversations between Makara and W. These said conversations were searched and assessed by police officers after they had received them on W's phone, and they were not accessed on Makara's phone. It is evident that Makara had no control over the matter at hand during the search because of the certain circumstances of the case. W, however, did have the exclusive control over the text message conversations since they were on his phone. W was able and free to disclose them to anyone if he wished to do so, and anywhere or any time. Furthermore, Makara did have reasonable expectation that his personal privacy in those text message conversations on W's phone, despite his lack of control over them, serves the interconnected relationship between privacy and control that has long formed part of the court's Section 8 jurisprudence. Moreover, it is equally compared with the basic principle that any individual can and will share whatever information that they see fit in a free and democratic society. However, it is also important to note that courts have no way of knowing how to assess the strength of M's expectation of privacy, meaning that courts have to access Section 8 of the Charter. Analysis. In my opinion, I do agree that Makara had the right to argue that his Section 8 of the Charter rights were violated, because in an electronic text message conversation between two or maybe more people, it is expected under reasonable expectation it remains private. As well, that Makara did not have control over W and what W had on his phone, since he could have either deleted them or not. W had more power over what he could or want to do with the messages, since the messages found on his phone held the information regarding Makara and his future. Yes, the courts have no way of knowing how to assess the strength of M's expectation of privacy. However, the text messages on phones or any technical device, usually they are expected to hold privacy, especially individual messages to only one other person. Survey question. Do you think that Makara had enough reason to argue his Section 8 Charter right was violated in the terms of this case's circumstances? Yes or no? Thank you.